We have already established that the notice that was sent out is solely as to your motion, emergency motion for a temporary restraining order. And that's what we're here to hear. We're here today to hear.
All right, may it please the court. This case concerns the integrity of joint legal custody and the rights of the children in their spiritual autonomy, and a co-parent's repeated attempts to bypass lawful procedures under the pretense of religious obligation. And I'm seeking a narrowly tailored restraining order, not to block my children from learning about their mother's faith, but to prevent an irreversible act that would violate the court's prior orders and their right to choose their religious path freely and knowingly. Beginning around April 13th, Cindy and I, at my initiation, began, well, it began earlier than that, but the most recent effort began around April 13th, where we were developing mutually a religious education agreement to be incorporated into our consent decree for our forever going forward, respecting her rights and respecting my rights, her beliefs and my beliefs. Throughout the course of this, she kept changing the language to make it more ambiguous.
Well, let me understand something, Mr. Kelly. This is an agreement that you and Ms. Hetzler were trying to arrive at that was outside of the auspices of the court. Is that correct?
Yes, sir.
Okay.
It was our.
Then how does the court have any ability to, or authority to control y'all's act? How does it violate a court order that's in place now?
That agreement does not.
Okay.
We were trying to tailor that agreement to present it to the court to incorporate it into our parenting plan.
Okay.
Under Georgia law, the standard before the court is a preponderance of the evidence. That is more likely than not that the plaintiff intends to facilitate and administrate the formation of the Catholic Church and the Catholic indoctrination and other religious sacraments without my consent or knowledge. The facts overwhelmingly support that conclusion. First, she has a documented history of excluding me from major religious milestones. She arranged for the children's baptisms without notice or proper discussion. She brought them to and enrolled them in vacation Bible school without proper notice or discussion. She taken them to multiple religious activities without any notice to me, despite a clear requirement for a reasonable consultation under our custody order. Second, over the past 2 to 3 weeks, we've attempted to negotiate this religious education agreement. And I presented multiple drafts grounded in mutual consent, transparency, and the children's right to spiritual maturity before either of us impose our beliefs upon them. Plaintiff has rejected every version, inserting ambiguous language like religious formation and sincerely held beliefs, and ultimately declared that she would, quote, follow the order, without defining what that means or committing to shared decision-making. And the timing, on April 16th, she asked me for a custody exchange. She asked me to modify a logistical error in our custody centered around May 25th and 26th. And sort of as an afterthought, she said, oh, by the way, since I'm doing this, will you be willing to give me this additional day of May 4th? Now, during these negotiations, we haven't talked about agreeing to religious formation. But throughout the course of the negotiations, she continues to use the word religious formation. And I have to stop and correct her. Cindy, we are agreeing to religious education.
But Mr. Kelly, I'm trying to be extremely patient, okay? I'm trying to understand if y'all are trying to work out an agreement and she doesn't want to agree, why does that constitute an emergency situation if she's got the ability to make the decisions in regards to religion?
That decision goes away tomorrow, Your Honor.
Okay.
And she has all of her.
Who has it after tomorrow?
It's mutual consent no changes without consent.
No changes without consent. So it goes back then to the legitimization order.
Correct.
All right. And this religious ceremony or course or whatever, however you characterize it, doesn't take place, or the communion was what it was. I've been extremely busy, Mr. Kelly, and so the communion is what you're having an issue with. And tomorrow, the order that gives her the right to make those decisions expires by what you're telling me. So why, and it reverts back to a previous order, what's the need of this court intervening? If the time frame of the event that you find, for lack of a better word, objectionable, won't occur until after the expiration of the order that's in place now.
Because the preponderance of evidence indicates that she plans to proceed with that despite the order reverting back.
Well, if she violates an order of this court, then this court, upon proper motion, will deal with that scenario. But I can't pre-order her to do something because she's already, for a lack of a better way of explaining it, she's already ordered not to do it by what you're saying. And I'm going to look at that order. She's already find it now. What was the case number for the legitimization case?
2020 v. 100, I believe.
That's not the case number. Can you find it for me? V-100. 0100. Okay. That's why it wouldn't come up. Well, I'm reading that order, and it says, and this is the final, or no, excuse me, let me make sure I correctly state what I'm reading from. All right, this is a consent final order in 2020 V 0100. And on the second page, beginning with the first full paragraph, it says all decisions pertaining to the education, discipline, health, extracurricular, and summer activities, religious training, medical and dental care, and welfare of the children will be decided by both parties after reasonable and adequate discussion. In the instance of a disagreement as to a decision affecting the child, the parties agree that after a good faith effort has been made, the mother, and once again, I reiterate, the mother shall have final decision regarding education, and the father shall have final decisions, authority with regards to medical matters. Excuse me, I'm having a hard time getting it situated on my computer. And it appears to be void of what happens in regards to religious training. Is that your understanding, Mr. Kelly?
No, sir.
Where does it say?
There's two references to it.
All right, where's the other reference?
There's the consent decree, and then there was the final order, or the parenting plan.
All right, the parenting plan. You're saying it's in the parenting plan?
I believe so, sir. It's right after it says that I have final decision-making over medical matters. It says that in regards to religious and extracurricular activities, the parents must mutually agree.
Well, that's not in this, what I'm reading from. Okay, so hold on just a second. Hang on just a second. Let me get to the parenting plan. What page are you referring to, Mr. Kelly?
I don't have a copy of it in front of me, sir. And I don't have access to the internet to download to access it.
It seems, let me go a little further, but from what I'm looking at, Mr. Kelly, it appears to mirror the same language that's in the consent agreement.
If I could, Your Honor, and perhaps the plaintiff will stipulate that it actually says that somewhere in that document that.
Have you got a hard copy of the parenting plan, Mr. Harrington?
I apologize, Your Honor. I did
How
not-
about running out that parenting plan?
We do not agree with his interpretation.
Mr. Harrington, when I want to hear from you, I'll address you. Is that here?
Yes, sir.
Let me solve this problem first. You may very well be right, and I might not need your comment.
Yes, sir.
Your Honor.
Run out that consent order also. Yes, sir, Mr. Kelly.
If I could have access to the court's Wi-Fi, I can get tell you exactly on what page it is.
I'm fixing to have a hard copy, and you can do that. I'm gonna look and see if I can find it. If I can't find it, I'll let you look at that hard copy, Mr. Kelly. Thank you. Well, all right. I wasn't able to see this, but looking at the contract or settlement, contract of settlement, it says if a mutual agreement cannot be reached by the parents on matters concerning religion or extracurricular activities, then no decision will be made by either parent until an agreement can be reached. Further, neither parent will change the names of the minor children without the written consent from the other parent. Is that what you're referring to?
Yes.
That's in the contract of settlement, Mr. Kelly. It's not, doesn't appear, let me look and see. Well, you didn't run out. Is that the parenting plan there?
Is the consent final order?
All right, let me see the parenting plan. It's attached to this. I got it. Thank you. And that's consistent. That language is consistent with the consent final order. And it's consistent with the parenting plan. Though the verbiage in the parenting plan is somewhat different. Y'all want to look at this?
Your Honor, I don't need to see it. I know what it says.
No, sir.
All right, so come May the 3rd, is that right?
Yes, sir.
Then she can't make any decisions about religion without y'all coming to an agreement.
Thank you, sir.
And that order is in place. Mr. Harrington?
Your Honor, this is all presupposing that she is going to do what he says she's going to do.
No, sir, it doesn't presuppose anything. I'm saying there's already an order in place that she can't do what he's presupposing. And if she does what she's presupposing, he thinks she's going to do, if she does it, then his remedy is to file a contempt in front of this court because of her failure to follow the consent final order, the contract of settlement, and the parenting plan.
I understand that, Your Honor, but what he is suggesting that she is going to do in his pleadings is that she is going to allow the children to have their first Holy Communion. She is not going to allow their children to have the first Holy Communion. However,
And that's exactly what I'm saying, Mr. Harrington. I don't see the need for this court to issue an order in that regard because she doesn't have the authority to do that. If she does, and he brings a contempt action against her because she's done it, she did it, this court will have to deal with that scenario.
yes. May I be completely transparent with what is happening this weekend so that no one can...
I think all of this is premature. The issue is whether or not one or the other or both of these individuals follows what order is in place. And as of this second, we don't have a violation. You disagree with that, Mr. Harrington?
No, sir, I certainly agree with it, but...
Mr. Kelly, you agree with that?
Yes, sir, I agree with that.
Okay. So I'm going to enter an order saying that this motion is moot.
Thank you, sir. I apologize for wasting the court's time.
Mr. Harrington, you have something you want to say?
I would like to, but I do not wish to offend the court.
Well, you won't know that until you say it, Mr. Harrington. So if you think you are going to offend the court, I suggest that you not say it. But if you're not going to offend the court, then you're free to say whatever you'd like to say.
I don't believe it should offend the court. All she wants to do is allow the two children to be there when they're siblings.
And I've already said I don't care about that.
Okay?
I don't know how plainer I need to make that, Mr.
Yes.
If it's her weekend, she's entitled to have the children do what she wants to do, subject to whatever the restrictions are in the orders. You understand that, Mr. Kelly?
Yes, sir, I do.
It's no different than her can't tell him what to do when the children are in his custody. All right. Thank y'all very much. My verse.
contemplated the right of the accused to refuse such test. When somebody makes a determination as to the type of test that they are going to make, essentially that test must be offered to that individual. In this case, there was an affirmative statement made by Mr. Smith to elect to take the breath test. That was repeated, and testimony came out that he, at multiple points, made the determination that he wanted to take a breath test. He even indicated that he has a fear of needles and he did not want to consent to a blood test. However, a determination was made by somebody who was not the officer, allegedly through the testimony that came out, that was part of EMS, that he needed to be transported to the hospital. At that point in time, the option to take a blood test or a breath test was essentially revoked, and the only option was a blood test. Given the fact that the officers testified that they didn't make a determination that there was any sort of medical necessity, they didn't make the determination that he needed to go to the hospital. In fact, Officer Landwehr testified that he was standing appropriately, he wasn't swaying,
Come on, counsel.
he was able to
Come
walk.
on, counsel, seriously. You've seen the videos. You've seen the videos I've seen.
Sure, and in those videos, he does make the
He
statement
can
that
barely walk. He is groaning. He is the one who wanted to go to the hospital.
well, Your
That
Honor,
is clear from the video. So let's not, come on. Let's argue the actual evidence that's before me. And
sure. As Your Honor has seen in the video, Mr. Smith makes a direct statement, I do not need medical care. I do not want to go to the hospital. That is what
then
we
he's
know.
in the back of the seat moaning. He is talking to EMS. And then he's obviously having a conversation with EMS when they said, no, we're going to bring him in. Now we're going to evaluate him. And then he can barely walk. He can barely get up the stairs. He is in significant pain. Going to the hospital was his idea. It
Your-
wasn't the officers.
Your Honor, I think what the court has before it in reviewing the same video is an objective response from Mr. Smith. I do not want to go to the hospital. I do not need medical care. And then everything the court has just now referenced is an inference from some sort of action or behavior. So when the court has to balance the competing inferences made based on behavior after a serious accident and his objective statements as to his intention, how he's feeling, whether or not he wants to go to the hospital, I think the court should give greater weight to the actual words.
All right, then how about the actual words of the statute? If the person is receiving medical treatment where there's not a breath test, a machine, or the quote, the test shall be of the person's blood. So how do we ignore that?
Your Honor, and I think this is why it is hard to separate from the constitutional motion in that the statute doesn't talk to it directly, but if it's a coerced,
Where's your evidence of coercion?
well, specifically that Mr. Smith did not agree to go to the hospital and then was taken to the hospital.
The evidence on the evidence is that he wanted to go to the hospital. All right, go ahead.
I believe that there's competing evidence as to whether or not he wanted to go to the hospital. And I think the greater weight should be given to the fact that he specifically said he did not want to go to the hospital.
All
So
right,
at
anything
that
else?
point, it was coerced and that he had no choice but to provide a blood test without making the medical determination when he was clearly conscious and able to give his own opinion as to the medical necessity of going to the hospital at that point, after making a determination that he wanted a breath test.
Okay.
So at that point, effectively 42-4-1301 was not being complied with, given the fact that he was not given a good faith option between a blood test or a breath test.
Anything else?
Your Honor, I would just supplement my record as to the issue of Miranda, in that defense would also contend that the statements made by Mr. Smith were not voluntary, largely resting on the record, but essentially there was testimony that,
What statements are you really concerned about?
so my defense's contention would be that this goes to all statements as far as voluntariness. The testimony that nobody really understood whether or not he had any sort of head injury, but there was a very significant accident. The testimony that part of their indication for impairment was repetitive and slurred speech, which could be caused by a head injury or other causes, all go to the fact that there is the great possibility that the statements that Mr. Smith was providing were due to some other sort of factor rather than a voluntary action on his part to convey the information. He was simply not acting voluntary when making those statements. And that would be from the point of contact with the initial officer.
What's the test for voluntariness?
I believe it's totality of the circumstances. Again, I'm just pulling up the site. Yeah, so it looks like there's a number all relating to totality of the circumstances. If the suspect was in custody or free to leave, if the suspect was aware of his situation, if Miranda warnings were given before any interrogation, if the
Right,
suspect.
so we've got the Jennings factors. But
Well, this
before-
comes from
Before we even get to the, you're a young person, you may call it something newer. I'm old, so I still refer to them as the Jennings factors for the same things. But before we even get there, what is a necessary prerequisite for there to be a statement to be involuntary?
Correct. Are you, I mean, the custodial status of the individual, if that's what the court's,
Talking about government coercion, there has to be evidence of coercion. So let's start at the beginning. When he walks up to the officers, you're claiming there either has to be coercion or you're referring to the Supreme Court case, Colorado Connolly, specific issues dealing with this head injury you want to indicate there's evidence of. So you either need police coercion or you're doing an analysis under Colorado Connolly. So then what is the analysis then if you're going to talk about the specific characteristics of the defendant, in this case, this alleged head injury? When do these specific characteristics rise to the level of creating the inference that his statements were not voluntary? The answer is that personal characteristics are relevant only as to voluntariness. They only become relevant as it relates to the police conduct in the particular case, as it might evidence the defendant's susceptibility to coercion. So there still has to be coercion, and there's got to be evidence that somehow this specific trait made him more susceptible to this coercion to elicit a response. So if we start in the beginning, make that argument.
Sure, Your Honor. And so, I mean, taking everything, and especially with the Connolly case, if we were to assume, for the sake of argument, that Mr. Smith had a head injury and that the actual physical impact of a head injury is to make him more susceptible to some sort of government coercion or some sort of pressure by the officers who were there at the time. What we do know is that officer who arrived on scene first immediately started questioning him. Because he wasn't in custody, he believed that he did not have to Mirandize him, but he asked him questions such as how much he had to drink. He testified to the response that Mr. Smith gave him. So if, for the sake of argument, it's understood that Mr. Smith did have a head injury and this officer is asking him inculpatory questions, understanding that he has a pattern of speech that is slurred and repetitive and consistent with a head injury, then the fact that a government official, an officer in uniform with a gun, fully dressed, is asking him inculpatory questions is in itself coercive, and that it is used to try to elicit a response from somebody who has a physical impairment that makes him more susceptible to answering questions out of the norm of how somebody who was apprised of their Fifth Amendment right and or was aware of their circumstance would be normally likely to answer. So the physical impairment of a head injury puts him susceptible to the mere asking of inculpatory questions, which then become coercive by themselves.
All right, anything else?
No, Your Honor.
Mr. Sunshine?
Yes, Your Honor. So the people do agree with at least the line of Your Honor's questioning.
There does not appear to be any coercion from the police. The police are consistently, the officers are consistently polite to Mr. Smith. In fact, he comes up to the police. He asks to be placed into custody. The police say no, or police do not place him into custody. They are consistently polite during the SFSTs, offering to get medical attention, and it is only after probable cause is established, following his failure of the SFSTs, that he is placed into custody. Afterwards, they are consistently polite and courteous to Mr. Smith. They don't ask him any questions that would intend or intentionally elicit or reasonably elicit an incriminating response. So we do agree with the court that there is no government coercion here. Additionally, we would note that there is ample evidence for reasonable suspicion and probable cause. We would note upon being approached by an officer who is just showing up on scene as the first officer on scene, he says he should go to jail. He shows indicia of impairment, including alcohol on his breath. He also says on the video that he ran a red light and that he had several drinks. And then he proceeds to fail his standardized field sobriety
He
test.
said two, not several.
Well,
I think his words were two.
two. He says that he has 2 beers. I think he also says that he also has a little bit of weed and that alcohol would be found in his system if they were to look in his system, which is not the most articulate way of putting it, but that's roughly what he says. There is ample reasonable suspicion in following his failure on the SFSTs. There is probable cause for the arrest. We would note that under Turbine, which is cited in the defense's motion, both of the defense's motions, that the breath test that was suppressed by the court was not suppressed because the police needed to change the manner of the test. In that case, the defendant or suspect had to was initially said that he wanted a blood test. There were issues at the hospital. He was then told you can get a breath test or you would lose your license. It was the fact that the police said that you would lose your license, coercion, or some kind of threat that resulted in the breath test results being suppressed in that case. As Your Honor heard today and saw on the body-worn camera, there is no threat made to Mr. Smith. Mr. Smith is asked very politely if he would take a blood test. The question of his license is never brought up. There is no threat. There is no weapons drawn. There was no coercing him into getting a blood test. They simply state that you're going to the hospital. We can't do a breath test there. Will you consent to a blood test? And in 2 instances, Mr. Smith consents to the blood test.
Does he even have to consent?
He does have to consent, Your Honor. Otherwise, we would need to get a search warrant.
If the person receiving medical treatment is at a location in which a breath testing instrument certified by the Department of Public Health and Environment is not available, the test shall be of the person's blood.
Yes. So at least going back to my county court days, where we dealt more with DUIs, my understanding of that is that an individual does not have the right to refuse. And that is why if an individual refuses, that the refusal itself can be used at trial. So he, in theory, could refuse to take a blood test.
But otherwise it shall be blood.
Yes. So that's where we are in this case. We would ask that the court deny defense's motion.
At your phone? Do you need a minute?
Judge, can we take a quick break or just let him do it?
Sure. Go ahead. guess to begin, I would suggest that before people put things in motions like no conceivable semblance, we probably back off our adjectives a little bit. And every time in a motion you say something is clear, well, if it's so clear, you don't have to say it. But analyzing this situation, from what I saw in the video and based on the testimony, the defense is arguing, in essence, that there's a Fourth Amendment seizure. And the test for a Fourth Amendment seizure, as we indicated, is whether under the totality of the circumstances, the encounter between the police officer and the citizen would demonstrate to a reasonably innocent person they weren't free to decline the officer's request or otherwise terminate the encounter, which is our threshold definition of when there's a seizure under the Fourth Amendment. Case law is very clear, and the standard, well, we know from the text of the Fourth Amendment that it's only unreasonable seizures that violate the Fourth Amendment. And we know that there can be different types of seizures. There are arrests, there are investigative stops, there are detentions, and then there are consensual encounters. A consensual encounter consists of voluntary cooperation by an individual to non-coercive questioning by a police officer. People versus Marujo, 192 P. 3rd, 1003. The test in that case for a consensual encounter is whether or not a reasonable person would believe she was free to leave and disregard the officer's request for information. People v. Thomas, 839 P. 2nd, 1174. Contrary to the arguments of counsel, inherent social pressure to cooperate with a police officer is not itself a sufficient basis for declaring an encounter non-consensual. That's the Heilman case, 52 P. 3rd, 224. The evidence that is very clear on the video and through the testimony is that there was no display of control or authority over the defendant by any police officers, that at least when the initial officer is speaking, Officer Latner, there's one officer at some point, others walk up and walk away at some point. There is indeed Officer Landwehr there, but the number of officers, the way they approach, the way there's no surrounding, there's no threatening, there's no weapons, there's no demanding information. The officer's tone of voice is always very nice and conversational. And in fact, at one point, the defendant himself tells Officer Latner, there should be more police officers like you. So this was a friendly encounter. Initially, the defendant walks up, makes the statements about put the cuffs on or arrest me, that he's been drinking, about how the accident happened. And the statements there are somewhat conflicting. At some point, he does appear to say he's responsible. At other points, he seems to indicate that the other person, the other car caused it, caused the accident. But he's already admitted he drinks, that he was driving, that he was involved in the accident, and at least some of his statements were that he was at fault in the accident. By this time, officers do have suspicion of criminal behavior, at least a DUI, if not And the officer at some point throughout all of this realizes that people are being taken away in the ambulance. So there is a specific basis in fact for the officer to have determined that a crime has taken place. Not only has the defendant admitted potentially DUI and causing an accident, but he's basically also admitted at the very least vehicular assault potentially. So the tests for an investigatory stop have been met. The officers have a specific articulable basis in fact for suspecting criminal activity. And at this point, the purposes of any seizure, the investigation have to be reasonable. Investigating, doing the roadside maneuvers and continuing to investigate. This was short and these were reasonable, and the scope and character must be reasonably related to the purpose as they were. The field sobriety tests are reasonably related to the purpose of the investigation of DUI, vehicular assault. I think at some point they found out someone that you can hear on the audio that Officer Latner does find out that someone has deceased, so it has died. So now, vehicular homicide is now reasonably at play. The officers then develop probable cause for the arrest, not only through his admissions that he has committed a vehicular assault, or at some point, once they know about the death, a vehicular homicide through the defendant's own admissions, but through the officer's own observations, my notes of exhibit. Where was it? Oh, as early as 4 minutes and 55 seconds into Exhibit 1, that being Officer Latner's body-worn camera when they're talking about the tests that they're going to do and making reference to the field sobriety tests. By that time, I mean, the officer didn't use the words. I don't know why, but obviously under 701, it's an appropriate lay opinion as to whether someone's intoxicated. The nice thing about the videos is that I, as a finder of fact, can look at it, and the video is clearly showing somebody who has clear signs of intoxication. And it was obvious to the officer as well, because at 4 minutes and 55 seconds, he says, yeah, I've got a strong feeling we're going to find indicia of alcohol in your blood, because he is obviously impaired. So they have the probable cause, notwithstanding the 6 out of 6 clues. The defendant numerous times says, I'm not going to be able to do these tests. And in the beginning, it has nothing to do with his ankle. He starts off complaining about his shin. And when they start talking about the test, he's like, I'm not going to be able to do this. The officer, Landwehr, numerous times says, well, do you want to stop? He goes, no, I'll try. And by the end, it's clear that the ankle, things are getting worse. As time goes on, he goes from, the officers testified, and with what matched up to the facts that I saw in the video, that in the beginning, he did appear to be walking just fine. And he was complaining about his shin. And then eventually, by the time you get to the walk and turn, he's having problems. And now he's complaining about his ankle. But even before he had problems walking, the evidence is that he's basically making left-handed admissions that he's not going to be able to complete tests like a sober person. He knows it, and he's basically making left-handed admissions of that on the video. And so then even if you take away the performance on the walk and turn or attribute that to his hurt ankle, that there's other facts to supply the probable cause for the arrest. So the allegation in the motion that the officers lacked reasonable suspicion is denied. And I am finding there was probable cause for the arrest. As to the express consent statute, Officer Landwehr at least 3 times explains to the defendant that if you go to the hospital, they're not going to be able to do breath. It's going to have to be blood. At Exhibit 2 at 23:30 and 30 seconds, when she's giving it, she asks specifically, he chooses breath, and then she specifically says, you don't want to be evaluated at the hospital, because if we go to the hospital, they can evaluate you there, but they can't do breath. It's going to be blood. And he says he wants breath. He's hooked up. Contrary to the arguments of counsel, on Shiplet versus Colorado Department of Revenue, 266 P 3rd 408, Court of Appeals has held that the exchange between an officer and an individual regarding blood or breath testing does not constitute an attempt to interrogate or take a statement. I've heard no case law to the contrary. That is not unusual. There's often much communication, booking questions, for example, that are not deemed to be interrogation, and short of other case law being cited to the court, the Shiplet case is what I'm going to rely on, that asking someone blood or breath does not create interrogation, notwithstanding the fact that he had handcuffs on. He was in custody at that point. That's clear. No one's arguing that, but that's not interrogation. They were going to give him the breath test that he asked for. He then chooses himself, or the EMT chooses. He voluntarily goes to the hospital, and everything I saw in the video indicates that he wants to go to the hospital because he is now in severe pain. He can barely walk. He can barely make it up the stairs to the elevator. He is groaning, and he is told at least 2 more times, look, if you go to the hospital, they can't do breath. It's going to be blood. At one point, I think before they get in to the ambulance, I wrote at 23:35:27, are you okay with blood? And he said, yeah, okay. But then he said, no, not really. I'm a big guy. I've got tattoos, but I'm scared of needles. And then again, while he's in the ambulance, at 23:46, the officer again says, look, there's no breath test machine at the hospital. Are you going to consent to blood? He says, sure. And he's like, I already told you what you're going to find. So the motion to suppress based on violating express consent is denied. All of his statements were voluntary and not the product of coercion. The only questions I have really is in Exhibit 3, because there is no questioning. Once the handcuffs are on, once he's in custody, there is no interrogation. Until Exhibit 3, arguably, where's home at is asked. On the one hand, what's your address is a standard booking question, which could conceivably be part of the booking exception. And he has a hard time answering the question. He eventually says 1822. The officer then says, wait, is that home or where you're going to? Which is that your home address still could fall under the booking questions exception. Is that where you're going to? Probably is custodial interrogation. But he says, that's my home address. That's my home address. And then there's how long have you been living there? He says 6 years, quite a while. I think the how long you've been living there, I don't know that there's any real argument from the prosecution that that's not custodial interrogation. I don't know how long you lived there is a booking question. I am going to find that the original where's home at, getting the address is not interrogation, but the how long have you been living there is. So I would suppress the how long you've been living there. And really the answer is just 6 years. And the officer said, that's quite a while. That's quite a while. And then she immediately afterwards, pretty shortly thereafter, says, I'm going to be following the ambulance, and the video cuts off. So other than the one statement of how long have you been living there, and the answer, otherwise defense motion is denied. Now, as to the second motion to dismiss, the lack of evidence under turbine is denied. That aspect is denied. The prosecution has asked for more time to address the allegation of, I guess, the express consent statute being vague. And does overbroadness also go to, your overbroad argument is also as to express consent? Okay. And I will note, just appropriately, the defense did serve the Attorney General. The Attorney General has not entered their appearance. I presume there's been communications between the Attorney General's office and the DA's office that they weren't going to, so now the people are going to respond. How much time would you like to respond to the 2 remaining constitutional aspects?
I think 2 weeks is fine.
All right, let's have looks like we've got time before the trial. Trial set in September. All right, we are at May 2nd. Let's have the response due May 16th. And I will, if there's going to be a reply, let's have it due May 30th. If you feel the need to reply. I can't imagine that we need oral argument. If either side wants oral argument on the constitutional motions, then you can ask for it, put it in the motion. And if you ask for it, I'll consider whether or not we need it. But it probably feels like something that we don't need oral argument on. The court will just be able to rule. Other than that, we've got pretrial conference on the 18th. I think I said before, but Mr. Smith, that is the last day that I will accept any plea that does not include count 1. Trial currently set for September 2nd. I have this one listed as the priority case that week, so if there's any conflicts, this is the case that I would be keeping, and I would intend to try it here in 4G. We have it set for 4 days. We still think that's going to be sufficient?
And I thought,
Wait, do we set it for 5?
yeah, that was my understanding.
We did, and then I miscalendared it. Okay. So, all right, so then it'll go through the 9th. Do we think that's gonna still be enough time?
I think so.
Yes.
Or through the 8th? Through the 8th, right? 1, 2, 3, 4, 5 days would be the 8th.
Yeah, 8th that Monday.
Say again?
Sorry, yes, the 8th being that Monday,
Yeah.
that looks right.
Okay. All right, anything else from the prosecution?
Yes, Your Honor. Just one thing, just for full candor to the court, since Your Honor said that you presume that the people in the Attorney General's office were in communication. The people in the Attorney General's office were not in communication.
All right, then, once you saw nothing
Once
filed, you have inferred that they are not going to file anything.
Yes.
So, anything else from the defense?
No, I can't think of anything. I don't. Okay. Yeah, nothing further from the defense.
All right, here are the exhibits. We'll hold on to the exhibits. As part of the record, they were admitted only for the purposes of this hearing. All right, then we'll see everyone at the pretrial conference unless either side asks for oral argument. The count to which you are pleading guilty, the criminal mischief count, the class 4 felony between May 1, 2023 and December 31st, 2023, you in the course of a single criminal episode did unlawfully, feloniously, and knowingly damage the real or personal property of Louisa Robinson, the aggregate damage being $20,000 or more, but less than $100,000. To that count, you plead guilty or not guilty?
Guilty.
Count 4, the class 1 misdemeanor between May 1, 2023 and December 31st, 2023. You, who had been personally served with a protection order issued pursuant to section 18-1-1001 of the Colorado Revised Statutes, unlawfully and knowingly contacted, harassed, injured, intimidated, molested, or threatened Louisa Robinson, a protected person, a type of conduct prohibited by the protection order. To that count, do you plead guilty or not guilty?
Guilty.
All right, before I accept your plea, let's make sure you understand a couple of things. First, the potential penalties. Pardon me. Class 1 misdemeanor carries a maximum penalty of of up to 364 days in the county jail. Do you understand that?
Yes.
And the class 4 felony carries a potential sentence to the Department of Corrections of between 2 to 6 years. Unless there are aggravating circumstances, then it could be as much as 12 years. If you were sentenced to the Department of Corrections, there's a 3-year period of mandatory parole. Do you understand that?
Yes, Your
Honor. All right, I see you have the paperwork there in front of him.
He does.
All right, so that document you're looking at there, the defendant's request to plead guilty has been scanned and uploaded into the court's file, so we're looking at the same document. Next to each numbered paragraph, there are initials. Did you put those there?
Yes, sir.
Does that mean you went through this line by line with your attorney?
I did.
And if you had any questions, did she answer them for you? Do you have any questions for me about anything that's in that document?
No, yeah.
Main thing I want to call your attention to, if you turn to page 2, there's a paragraph 5. It's got lettered paragraphs A through K. These are the rights that you have, right to be presumed innocent, have the DA prove it, appeal, etc. As outlined in this document, do you understand that you have each and every one of these rights?
Yes, sir.
You understand if I accept your guilty plea, you are giving up these rights. There is no trial, you're guilty, and we're going to sentencing.
Yes, sir.
All right, finally, sir, I do not accept pleas of guilty from people who tell me they're innocent. That's what trials are for. So now I'm going to ask Mr. DeCecco to tell me what facts he would prove at a trial that support these charges. And when he's done, I'm going to ask you if that's what happened. Counsel.
In your honor, can I just check? I heard the victim isn't able to hear right now. I just wanted to make sure we could hear her if needed.
Oh, well, we can, we're
Can you hear us,
broadcasting.
Ms. Robinson?
I don't know why we can't hear her. So I may have to select her microphone. Factual basis.
Starting on May 23rd, 2023, defendant contacted Louisa Robinson, with whom he had been in an intimate relationship. They have 2 kids together, violated the protection order from case 15 DR 2086 multiple times by sending numerable emails and text messages to her, calling obscene names, making threats, and causing severe emotional distress. As counsel and I can explain, the F for mischief is a bit of a legal fiction here to avoid the stigma of a stalking charge.
Is that what happened, sir?
Yes, Your Honor.
And you are admitting that you are or were in an intimate relationship with the victim in this matter, such that these are crimes of domestic violence?
We were married, so yes, sir.
All right, understanding the rights you're giving up, understanding the potential penalties, do you still wish to do this today?
Yes, sir.
All right, then I will accept your plea, finding that you've entered into it knowingly, intelligently, and voluntarily. My understanding, we're setting over sentencing?
No, Ms. Robinson is here virtually, so we can move forward with sentencing today.
Well, not if we can't hear her.
We cannot hear you, Ms. Robinson.
Let's try now.
Can you hear me now?
There we go.
Okay, great. Thank you.
And defense has no objection to moving forward with sentencing today.
All right, Ms. Robinson, is there anything you'd like the court to know? You don't have to say anything, but if you want to,
I've written a statement I'd like to read.
go ahead.
Your Honor, my name is Louisa Robinson, and I'm here today to share the deep and lasting impact that Tony's actions have had on my life and the lives of our children, as well as on our wider community. While the events of the past year have left us in a state of fear and uncertainty, I believe that with the proper supervision and intervention, there remains a possibility, albeit small, for Tony to move forward and make progress. However, this progress can only be ensured through a balanced approach, one that combines accountability with support, a carrot and stick approach to help him stay on the right path. Over the years, I've had to live under the shadow of ongoing threats to rape, kill me, kidnap my children, etc. Threats that have not only put my life and the safety of our children at risk, but also disrupted the fabric of our everyday lives. His repeated defiance of court orders and the explicit nature of his threats have forced us to take extraordinary measures for our protection. I have moved at least 8 times in the last several years because of Tony's actions. I have had to cancel personal and business trips for fear that Tony would take the children. I've incurred thousands of dollars in legal fees battling him for custody. I have been disinvited from vacations and plans with friends for fear that my presence would be a risk to their own families. I have been routinely humiliated and defamed online by Tony, who has made defamatory claims about who I am as a mother, a partner, a coworker, and a friend. He's continually made threats to me, the children, and the larger community. I don't believe these are idle threats. I choose to believe Tony, his continued words, and his actions. The cumulative effect of these events has left an indelible mark on my emotional and mental well-being. I continue to live in a heightened state of alert, which affects not only me, but also the children who deserve a safe and stable environment to grow up in. The strain has extended to every piece of my life, from where we live, to my work, to who we are friends with. Despite this, I do hope with the right level of supervision and the necessary interventions that Tony can be guided towards a path of recovery and improved behavior. There is a hope that he can learn to manage his actions and emotions, thereby reducing the risk he poses not only to himself, but also to myself, our family, and the larger community. I hope the support he receives, balanced by strict accountability measures, can serve as a catalyst for his rehabilitation. This balance is essential to ensure that while he is given opportunities to heal and grow, he's also held responsible for his actions so that the safety of our family and the larger community is not compromised. I am no expert in mental health or drug alcohol abuse, but I know enough to understand that it's up to the person afflicted by these conditions to address the issues head on. You can create as supportive an environment as you want to, but without them taking accountability and responsibility, very little will or can change. I respectfully ask the court to consider these factors. I understand that change is possible and that with the right measures in place, Tony might be able to work towards a healthier path. However, it is critical that this change is supervised and that he's held accountable through a balanced framework of support and consequences. This is essential not only for our personal safety, but also for restoring the trust and communal bonds that have been shattered by these events. Thank you for taking the time to listen to my story. I sincerely hope that the measures imposed will protect us from further harm, while also providing a structure through which Tony can genuinely improve and in time become a positive presence for our children and community.
So from your point of view, are there drugs and alcohol as an issue?
I think the primary issue, I believe, is mental health, and it's exacerbated by drugs. I don't think alcohol helps.
What's the drug of choice?
Marijuana has been the issue. It, from what I've seen, has made him deeply affects his mental health. But there are, I know he's been charged with other drugs, but I don't know the details behind that anymore. I'm very removed from the details. So Tony would be able to best speak to that. But I know there have been other drugs involved. I just don't know the details.
All right, thank you, ma'am.
Yeah.
Mr. DeCecco?
Your Honor, I've had many conversations with Ms. Robinson and Ms. Curry trying to find a resolution that's in everyone's best interest here. His behavior has been completely alarming and unacceptable. People understand that he deals with bipolar disorder and according to Ms. Robinson, rears its head in cycles. He could not exhibit symptoms for certain years. So what mattered to her is the longer deferred judgment to keep him compliant with mental health treatment and substance abuse treatment, as well as the law. He cannot possess weapons under Colorado law at this point, while he's on probation, the deferred judgment. I just wanted to serve as a warning that any violations of the protection order could result in new convictions and the conviction entering against him and prison time. So people are expecting exceptional compliance with probation. He definitely needs these services and will benefit from them if he's compliant.
Vince?
Thank you. Your Honor, I would just first note for the court, Mr. Robinson's limited criminal history. If the court takes a look at the pretrial report, it does list one prior felony conviction. I did look into that. That would have been a DM1 had it been charged in the state of Colorado. Mr. Robinson is currently on a deferred judgment for that offense. When he pled guilty to that, it was after the dates of offense in this case. So he will be supervised both in that matter and in this case. I don't want to downplay anything Ms. Robinson said. And in looking through the discovery in this case, a lot of the allegations are quite alarming. I think it is important to note that these allegations occurred nearly 2 years ago now, the first of which being in May of 2023. Since I've met Mr. Robinson in September of last year, he's been a very gentle and kind man. He has been an advocate for himself and for this case. And first and foremost, I should have mentioned, has felt nothing but shame, embarrassment, and regret for his behavior towards Miss Robinson in these days. I think for the court's information, Mr. Robinson was going through a difficult period in his life. He had moved abroad to start a business venture and try to restart his life, and it went really poorly. It was a failed business venture, and he was struggling with his mental health and with addiction, and that together led him to be in this situation, which he, as I mentioned, deeply regrets. He has been doing.
Hey, addiction, what are we talking about?
I do think primarily when we spoke, it was with alcohol and marijuana. And this combination does not play well with Mr. Robinson. I think it's interesting that both of those drugs are legal in the state, but sometimes together and for certain people, it's just not a good outcome. And he recognizes that and knows that. Your Honor, he began therapy back in October 2024 and has been going to those sessions. He is looking forward to continuing his mental health treatment with probation. And I do think that this plea agreement, it being 4 years, is the statutory maximum period of time allowed by a deferred judgment. It's a steeper sentence than I think a lot of people receive in this courtroom, but it serves a dual purpose. I think Mr. Robinson is going to be on the hook for that amount of time to make sure that he, even when he is going through the kind of valleys of his mental health, that he is able to continue to engage healthily with his community, to not reach out to Ms. Robinson, and to get the benefits of his treatment. And it also acknowledges his limited criminal history and the fact that he ultimately really just wants to get back on his feet to work to support his children. We did initially look into a potential outcome through Veterans Court and ultimately came to this instead, just given that Mr. Robinson is a veteran. And so, Your Honor, we would ask that the court grant the requested sentencing in this case, allow Mr. Robinson the opportunity to be on a deferred judgment and to follow along with the agreement between the parties.
So you have the right to tell me anything you'd like me to know before I sentence?
Just that I made a mistake. I know weed is something that impacts me different than it does most anyone I know. And it's certainly not my friend. And I know that very clearly. I've made this mistake on 2 occasions where it's been very clear, it leads to ramifications that I look back on, and there's no excuse, Your Honor. There really isn't. I mean, I know now that I need to stay away from that drug for whatever it does to my brain. They called it induced mania of sorts, but I mean, it's more of an induced wreck of my life, and it's destroyed me financially, emotionally, with my family, friends, and everyone else in the community, and I apologize.
Well, you're not the only one. We're not dealing with the 30% THC ditchweed that people grew up with in the 60s and 70s. And when I was down there, I was actually laughed at several times from judges on the bench when I would refer to legalization of marijuana as going to be a future problem. And because of exactly this, no one thinks about the science that goes into it. And now people are vaping 99% THC. It's not only you. What you've been dealing with here is not just marijuana. This is years of torture to the victim in this matter, and probably vicariously, if not directly, your children. I will go along with the disposition. I won't stand in the way of that, but there will be a jail sentence as a consequence. And I realize the people didn't ask for it, but on a situation like this, on a case with facts like this, you are going to be remanded and you're going to do a jail sentence for no other reason than punishment. It's absolutely unacceptable. and cannot be tolerated. And that's what I'm getting across. Everyone needs to know that this type of stalking behavior, if you do it, you cannot expect to walk out the back door of a courtroom. You walk through the side door. I'll grant you the 4-year deferred judgment on the felony count. January 29th, 2029 is the end of the deferred judgment date. That'll be supervised by probation and a concurrent period of 4 years of probation on the misdemeanor. You're gonna have to do domestic violence evaluation, complete that treatment, a substance abuse evaluation, complete that treatment, mental health evaluation and treatment if ordered, and anything else that your probation officer orders you to do. Don't know where this goes from here, but this is the helping hand that's being extended. I can't do anything else other than give you probation and go along with this potential for deferred judgment. If you choose not to follow through, then you come back in front of me on a 2 to 6. 30 days in jail is a condition of probation.
And Your Honor,
Report to probation within 48 hours of your release.
and just for the record, I do note some pre-sentence confinement credit from August 23rd to September 6th for a total of 15 days.
I'm not giving any credit on a jail sentence as a condition of probation. Do we have restitution?
No restitution.
All right, well, on to the finding of no pecuniary loss. Good luck, sir.
69.
Haran Smith.
Court is on the record in 3 cases involving the defendant Tristan Erdman. First case, 25 TRD 175, City of Conneaut versus Tristan Erdman. Mr. Erdman received a traffic citation back on March 10th, 2025. It shows his signature as having received a copy of the citation, and Mr. Erdman failed to appear for his initial appearance hearing. And so we are going to conduct an initial appearance hearing today, having suspended his license as a result of his failure to appear. Court is taking up as well City of Conneaut versus Tristan Erdman, 25 CRB 32. In this case, Mr. Erdman pled not guilty to 1 count of receiving stolen property, a first-degree misdemeanor on January 27, 2025. We conducted a pretrial conference on February 5th and February 24th, 2025. At a final pretrial conference on March 10th, the defendant failed to appear, and so we issued a warrant for his arrest as a result of his failure to appear. And that warrant has remained outstanding since March 10th. In case number 24 TRC 279, Mr. Erdman was convicted of operating a vehicle under the influence. The first offense in 10 years, a first-degree misdemeanor. I suspended 177 days of jail, actually 180, allowed him to attend a driver intervention program in lieu of 3 days in jail. I placed him on unsupervised community control for 5 years. He was convicted on July 15th of 2024. On January 27th of 2025, the Law Director's Office filed a motion to terminate Mr. Erdman's community control. And so we conducted a hearing on January 27th. Mr. Erdman appeared from the city jail and entered a not guilty plea to the motion or probation violation complaint. I set bond, scheduled the case for a final revocation hearing on February 5th of 2025. Prior to that scheduled final revocation hearing, the court issued an order on January 31st, 2025, indicating that the court had learned that Mr. Erdman was experiencing medical issues in the Conneaut City Jail and had to be taken to a local hospital several times to regulate his medication as well as for treatment. The court made a finding the defendant had spent 7 days in jail and received jail credit for that, and modified his bond to allow him to receive treatment. I basically reiterated the fact that we had a hearing scheduled, final revocation hearing, as well as a pretrial conference schedule on February 5th, 2025 at 2:30 p.m. and that Mr. Erdman was ordered to be at those hearings, and if he failed to appear, a bench warrant will issue. The defendant did sign a bond and a notice of hearing, so he acknowledged receiving that hearing notice to be there on February 5th. Mr. Erdman apparently somehow, and I haven't quite figured out what happened here. Somehow the hearing got continued to February 24th, 2025. Mr. Erdman did appear on February 5th, and it got continued to February 24th. Mr. Erdman was given notice of that. He signed a receipt to be there on February 24th. That hearing apparently got, on February 24th, got continued again to March 10th, 2025. And, I'm sorry, March 10th, 2025. Mr. Erdman at that hearing failed to appear. And so we issued a bench warrant for that as well. And so Mr. Erdman actually still needs to have a final revocation hearing conducted in this case as well. So the court's got to address bench warrants on the two pending cases, 25 CRB 32 and 24 TRC 279, and arraign Mr. Erdman on the new traffic charge in 25 TRD 175. Mr. Erdman is appearing at this hearing from the Conneaut City Jail. He is without counsel. Also appearing in the courtroom and appearing at table 1 on the video is probation officer Jonathan Balcom. Mr. Erdman, you received a traffic citation on March 10th, 2025. It indicates that you signed for this citation. Do you remember receiving that citation?
Yes, I do.
Okay, I'm going to read you your rights. Can we adjust the camera so I can see Mr. Erdman more better?
Yeah.
Thank you.
Better?
Yes, thank you. Mr. Erdman, I'm going to read you your rights, so please pay attention to the rights I'm about to read to you. You do have a right to be informed of and to understand the nature and the elements of the charge filed against you. You also have a right to know the potential penalties that could be imposed. You are charged with 1 count of driving under OVI suspension. That is a first-degree misdemeanor. If convicted of this offense, you face a minimum 3 days in jail up to a maximum 180 days in jail. I could impose a minimum fine of $250 up to a maximum fine of $1,000. I would be required to suspend your license up to 1 year. If the vehicle that you were operating on that day a 2011 GMC Acadia. If that was owned by you, that vehicle is subject to a mandatory immobilization of 30 days, as well as the plates are required to be impounded for 30 days as well. So those are the consequences you face. If convicted, it is a 6-point violation. And understanding that if you're convicted of this offense or any traffic-related offense, a record of conviction would be sent to the Ohio Bureau of Motor Vehicles and will become part of your driving record. And again, points may be assessed against your license for any moving violation. You understand the maximum potential penalties you face if convicted of this offense?
Yes.
You have a right to remain silent, not to say anything during this hearing that might incriminate yourself. Any statement you make could be used against you. You also have a right to a trial to the court. And because you are charged with an offense that carries a possible jail sentence, you have a right to a jury trial, provided that you timely file with the court a written demand for a jury trial. At trial, you have the right to confront and ask questions of any witnesses who would testify against you. You also have a right to use the court process to secure the attendance of any witness who you would want to testify on your behalf. At trial, you have the right to be proven guilty beyond a reasonable doubt and a right not to testify. You also have a right to have an attorney represent you in this case. And because you are charged with an offense that carries a possible jail sentence, you do have a right to court-appointed counsel and to have a lawyer assigned to represent you only if you cannot afford one. If you do qualify for court-appointed counsel, there is a $25 application fee and a $50 cost reimbursement assessment that apply. You also have a right to a continuance of this initial appearance hearing in order to retain the services of your own attorney or to consult with your own lawyer. If you are convicted of this offense or any related offense, you have a right to appeal the conviction or sentence. That must be done within 30 days of the conviction, and you would be entitled to a court-appointed attorney in the Court of Appeals if you receive a jail sentence and cannot afford a lawyer. Mr. Erdman, are you there?
Yes.
Okay, can you lift your head so I can see you?
I was reading the paper.
Okay. As I said, if you plead not guilty today, I will set your case for further proceedings after today, and I will set a bond. A bond is set by the court to ensure your appearance, and you do have a right to a reasonable bond. You are on probation with this court, so I do acknowledge that you are a U.S. citizen. Mr. Erdman, you have 3 plea options with respect to this charge. You can either plead guilty, not guilty, or no contest. If you plead guilty, that is a complete admission by you to the offense charged. If you plead guilty, the court will find you guilty, and then I will impose sentence. The second option is you can plead not guilty. If you plead not guilty, that is a denial by you to the offense charged, and as I said earlier, if you plead not guilty, I'll set your case for another hearing after today, and I will set a bond. The third option is you can plead no contest. If you plead no contest, that is not an admission of your guilt, but it is an admission by you of the truth of the facts alleged in the complaint filed against you. If you enter a plea of no contest, this court will find you guilty, and I will impose sentence without any evidence being presented against you. However, the plea of no contest cannot be used against you in any later civil or criminal proceedings. Mr. Erdman, do you have any questions regarding the rights or the plea options I've just explained to you on the driving under? I'm sorry?
No, Your Honor.
Okay. One thing I do need to address with you, if you are convicted of driving under OVI suspension in this case, and then are convicted of driving under OVI suspension at any time in the future, that any future charge could be enhanced in severity. It could be more serious because of this driving under OVI suspension conviction. Do you understand that?
Yes, Your Honor.
So with respect to the charge of driving under OVI suspension, a first-degree misdemeanor, how do you plead?
Not guilty.
Okay, the court will accept your not guilty plea. Are you asking the court to consider appointing an attorney to represent you?
No, Your Honor.
So you're going to represent yourself, Mr. Erdman?
I need to think on that. No, Your Honor.
Are you going to retain an attorney, Mr. Erdman?
Yes.
You are?
Yes.
You are represented by the public defender's office in the other two cases that are pending.
That's the one I want to continue with my cases.
So are you asking me to appoint a public defender or court-appointed counsel to represent you in the new case?
Sure.
Do you have any source?
Okay. So, yeah, I don't want to say nothing. I'm going to keep quiet.
Okay, well, that's good. You have a right to do that, but you have to answer my procedural questions. Do you have any source of income?
No question, Your Honor.
What's that?
Yes, Your Honor.
Yes, what?
Yes, I have a source of income.
Don't get mad at me, Mr.
I'm not getting mad at you.
Stand up straight and stand up straight.
You're confusing me with the question.
Okay. I'm going to consider appointing you attorney in this new case, so I have to ask you some financial questions.
Yes.
Don't get upset with me.
Don't need to get mad.
Mr. Erdman.
Yes.
You've been out on warrants. Don't mess with me.
I'm not messing with you.
Okay, now answer my questions. Do you have a source of income?
Yes, Your Honor.
Where do you work?
For myself, doing landscaping.
Self-employed.
Yes.
How much money do you make every week?
It depends on what I get, jobs I get.
On average.
I say about $200, $300 a week.
Okay, I find you qualify for court-appointed counsel. I will appoint the public defender's office to represent the defendant in this case, as he's already being represented by the public defender in the other cases. Now I'm going to address the issue of bond. So, Mr. Erdman, you need to help me understand why you have failed to appear for court when you're supposed to be there.
For one, I didn't know about it. I haven't gotten none of these in the mail at all. I asked for the 2595 code. I asked if I got mail there, and the mail that I got there was nothing compared to this at all. And
I got signed receipts in the file from you, Mr. Erdman, indicating you were given hearing notices.
From where?
What do you mean from where?
The driver was under suspension when I got pulled over. I do remember that one, but I couldn't remember the time.
Okay.
The other one.
Did you call the court?
Huh?
Did you show up to court?
No, I didn't know what time it was.
Well, I mean, that happened on March 10th. It's April 30th now. Why you've had 50 days to come to court and just show up and say, look, I'm sorry, I didn't know the time. I'm here to turn myself in on this case. Did you ever do that, Mr.
I've been too busy helping other people and not worried about myself.
Yeah. Okay, I'm done. On the driving under OVI suspension in 25 TRD 175, $10,000 cash surety 10%. Defendant is ordered not to consume or possess alcohol or drugs. He is subject to random chemical testing by probation and law enforcement. I am ordering an alcohol drug assessment on the defendant with the Lake Area Recovery Center. I'm ordering a urine drug screen today. As part of his assessment with Lake Area Recovery Center, I'm also ordering that he successfully comply with any recommended course of treatment that they recommend. I'll set this case for a pretrial conference. I will lift the bench warrants and warrant blocks in the other cases, but I will set bond. Bond is set in the amount of, in 25 CRB 32. This is the receiving stolen property case. If the defendant failed to appear, I will set bond in the amount of $10,000, cash surety 10%. The same conditions, not to consume or possess alcohol or drugs, subject to random chemical testing, subject to an alcohol drug assessment with LARC and a urine drug screen today. In case number 24 TRC 279, this is the probation violation complaint filed against him. I'll set this case for a final revocation hearing. Bench warrants is lifted, and we will set bond in this case in the amount of $10,000, cash surety 10%. And we will set this for a final revocation hearing in the near future. The bond conditions in all of these cases will apply. Not to consume or possess alcohol or drugs, subject to random chemical testing, subject to a LARC assessment, and comply with all recommended course of treatment, and subject to a urine drug screen today. Okay. Officer Malcolm, anything? Okay. You have any questions, Mr. Erdman?
No, Your Honor.
Okay, thank you. This matter is concluded.
Got these lights that goes digital dreams through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor, dark and twisted, sharp. In a way, there's no alarm. Dreaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes hear a sky so blue. In her jokes, there's a truth so true. With each stream, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor, dark and twisted, sharp. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor, dark and twisted, sharp. In a way, there's no